International law is a complex system of rules, principles, and practices that guide global interactions. It's not just a set of regulations, but a dynamic framework with sophisticated structures and processes. Primarily, it governs sovereign states, but also increasingly includes international organizations and individuals. Unlike domestic law, international law lacks a central legislative body or a comprehensive court system with universal jurisdiction. Instead, it relies on treaties, customs, and general principles recognized by nations. Ethical considerations, especially human rights, significantly influence it. The system is sustained through reciprocity, credibility, and mutual self-interest among international actors. International law lacks a single, universal authority for creation and enforcement. Its sources are treaties, customs, and general principles recognized by nations. Creation. Treaties. States create international laws by entering into agreements that are governed by the law of treaties. Customary practices. Consistent behaviors and practices of states, when coupled with a belief that such practice is legally binding, can evolve into customary international law. General principles. Mechanisms address international issues not already subject to treaty provisions or to binding customary rules. Enforcement. International Court of Justice, ICJ. The ICJ settles disputes between states, but its jurisdiction is based on the consent of the states involved. United Nations Security Council may authorize the use of force to compel states to comply with its decisions, but this is subject to the veto power of its 5 permanent members. Reciprocity and self-interest. States comply with international law because they recognize that consistent violations would jeopardize the value that the system brings to the international community. States that breach international rules suffer a decline in credibility that may prejudice them in future relations with other states. International law and the laws of a single country differ because international law is an independent system that exists outside the legal orders of particular states. Unlike domestic legal systems, there is no international legislature that can issue binding laws. The UN General Assembly only makes recommendations. Also, no system of courts possesses comprehensive jurisdiction in international law. The International Court of Justice's jurisdiction relies on the consent of the specific states involved. There is neither an international police force nor a supreme executive authority. International law arises from treaties, customs, and general principles recognized by civilized nations. Treaties are binding agreements between international entities, like states, and are expected to be executed in good faith. Customs, reflecting the decentralized nature of the international system, consist of the actual practices of states and the acceptance by states of those practices as law. General principles offer mechanisms to address international issues not subject to treaties or binding customs and may arise through municipal or international law. Judicial decisions and scholarly writings are also considered subsidiary means for determining international law. International law offers various peaceful methods for countries to settle disagreements, and none of these methods take precedence over others. These mechanisms include direct negotiations and third-party involvement through mediation and inquiry. International organizations, such as the UN, have increased their involvement since World War II, with many charters containing peaceful settlement mechanisms for disputes between member states. Binding dispute resolutions include arbitration and judicial settlement, where disputing states present their conflict before a binding tribunal or an existing independent court like the International Court of Justice, ICJ. The ICJ's decisions are binding and influential, possessing both contentious and advisory jurisdiction. International law, the body of legal rules, norms, and standards that apply between sovereign states and other entities that are legally recognized as international actors. The term was coined by the English philosopher Jeremy Bentham, 1748–1832. According to Bentham's classic definition, international law is a collection of rules governing relations between states. It is a mark of how far international law has evolved that this original definition omits individuals and international organizations, two of the most dynamic and vital elements of modern international law. Furthermore, it is no longer accurate to view international law as simply a collection of rules, rather, it is a rapidly developing complex of rules and influential though not directly binding principles, practices, and assertions coupled with increasingly sophisticated structures and processes. In its broadest sense, international law provides normative guidelines as well as methods, mechanisms, and a common conceptual language to international actors, i.e., primarily sovereign states but also increasingly international organizations and some individuals. The range of subjects and actors directly concerned with international law has widened considerably, moving beyond the classical questions of war, peace, and diplomacy to include human rights, economic and trade issues, space law, and international organizations. Although international law is a legal order and not an ethical one, it has been influenced significantly by ethical principles and concerns, particularly in the sphere of human rights. International law is distinct from international comity, which comprises legally non-binding practices adopted by states for reasons of courtesy, example the saluting of the flags of foreign warships at sea. In addition, the study of international law, or public international law, is distinguished from the field of conflict of laws, or private international law, which is concerned with the rules of municipal law as international lawyers term the domestic law of states of different countries where foreign elements are involved. International law is an independent system of law existing outside the legal orders of particular states. It differs from domestic legal systems in a number of respects. For example, although the United Nations, UN, General Assembly, which consists of representatives of some 190 countries, has the outward appearances of a legislature, it has no power to issue binding laws. Rather, its resolutions serve only as recommendations except in specific cases and for certain purposes within the UN system, such as determining the UN budget, admitting new members of the UN, and, with the involvement of the Security Council, electing new judges to the International Court of Justice, ICJ. Also, there is no system of courts with comprehensive jurisdiction in international law. The ICJ's jurisdiction in contentious cases is founded upon the consent of the particular states involved. There is no international police force or comprehensive system of law enforcement, and there also is no supreme executive authority. The UN Security Council may authorize the use of force to compel states to comply with its decisions, but only in specific and limited circumstances. Essentially, there must be a prior act of aggression or the threat of such an act. Moreover, any such enforcement action can be vetoed by any of the Council's 5 permanent members, China, France, Russia, the United Kingdom, and the United States. Because there is no standing UN military, the forces involved must be assembled from member states on an ad hoc basis. International law is a distinctive part of the general structure of international relations. In contemplating responses to a particular international situation, states usually consider relevant international laws. Although considerable attention is invariably focused on violations of international law, states generally are careful to ensure that their actions conform to the rules and principles of international law, because acting otherwise would be regarded negatively by the international community. The rules of international law are rarely enforced by military means or even by the use of economic sanctions. Instead, the system is sustained by reciprocity or a sense of enlightened self-interest. States that breach international rules suffer a decline in credibility that may prejudice them in future relations with other states. Thus, a violation of a treaty by one state to its advantage may induce other states to breach other treaties and thereby cause harm to the original violator. Furthermore, it is generally realized that consistent rule violations would jeopardize the value that the system brings to the community of states, international organizations, and other actors. This value consists in the certainty, predictability, and sense of common purpose in international affairs that derives from the existence of a set of rules accepted by all international actors. International law also provides a framework and a set of procedures for international interaction, as well as a common set of concepts for understanding it. International law, also known as public international law and the law of nations, is the set of rules, norms, legal customs, and standards that states and other actors feel an obligation to, and generally do, obey in their mutual relations. In international relations, actors are simply the individuals and collective entities, such as states, international organizations, and non-state groups, which can make behavioral choices, whether lawful or unlawful. Rules are formal, typically written expectations that outline required behavior, while norms are informal, often unwritten guidelines about appropriate behavior that are shaped by custom and social practice. It establishes norms for states across a broad range of domains, including war and diplomacy, economic relations, and human rights. International law differs from state-based domestic legal systems in that it operates largely through consent, since there is no universally accepted authority to enforce it upon sovereign states. States and non-state actors may choose to not abide by international law, and even to breach a treaty, but such violations, particularly of peremptory norms, can be met with disapproval by others and in some cases coercive action including diplomacy, economic sanctions, and war. The lack of a final authority in international law can also cause far-reaching differences. This is partly the effect of states being able to interpret international law in a manner which they see fit. This can lead to problematic stances which can have large local effects. The sources of international law include international custom, general state practice accepted as law, treaties, and general principles of law recognized by most national legal systems. Although international law may also be reflected in international comity, the practices adopted by states to maintain good relations and mutual recognition, such traditions are not legally binding. Since good relations are more important to maintain with more powerful states, they can influence others more in the matter of what is legal and what is not. This is because they can impose heavier consequences on other states, which gives them a final say. The relationship and interaction between a national legal system and international law is complex and variable. National law may become international law when treaties permit national jurisdiction to supranational tribunals such as the European Court of Human Rights or the International Criminal Court. Treaties such as the Geneva Conventions require national law to conform to treaty provisions. National laws or constitutions may also provide for the implementation or integration of international legal obligations into domestic law. Among the greatest achievements of the United Nations is the development of a body of international law, which is central to promoting economic and social development, as well as to advancing international peace and security. The international law is enshrined in conventions, treaties, and standards. Many of the treaties brought about by the United Nations form the basis of the law that governs relations among nations. While the work of the UN in this area does not always receive attention, it has a daily impact on the lives of people everywhere. The Charter of the United Nations specifically calls on the organization to help in the settlement of international disputes by peaceful means, including arbitration and judicial settlement, Article 33, and to encourage the progressive development of international law and its codification, Article 13. Over the years, more than 560 multilateral treaties have been deposited with the UN Secretary-General. Many other treaties are deposited with governments or other entities. The treaties cover a broad range of subject matters such as human rights, disarmament, and protection of the environment. The General Assembly as a forum for adopting multilateral treaties. The General Assembly is composed of representatives from each UN member state and is the main deliberative body on matters relating to international law. Many multilateral treaties are in fact adopted by the General Assembly and subsequently opened for signature and ratification. The Legal, 6th, Committee assists the work of the General Assembly by providing advice on substantive legal matters. The committee is also made up of representatives from all UN member states. The General Assembly has adopted several multilateral treaties throughout its history, including Convention on the Prevention and Punishment of the Crime of Genocide, 1948. International Convention on the Elimination of All Forms of Racial Discrimination, 1965. International Covenant on Civil and Political Rights, 1966. International Covenant on Economic Social and Cultural Rights, 1966. Convention on the Elimination of All Forms of Discrimination Against Women, 1979. United Nations Convention on the Law of the Sea, 1982. Convention on the Rights of the Child, 1989. Comprehensive Nuclear Test Ban Treaty, 1996. International Convention for the Suppression of the Financing of Terrorism, 1999. International Convention for the Suppression of Acts of Nuclear Terrorism, 2005. Convention on the Rights of Persons with Disabilities, 2006. United Nations Convention on Contracts for the International Carriage of Goods Wholly or Partly by Sea, 2008. Optional Protocol to the International Covenant on Economic, Social, and Cultural Rights, 2008. In many areas, the legal work of the United Nations has been pioneering, addressing problems as they take on an international dimension. The UN has been at the forefront of efforts to provide a legal framework in such areas as protecting the environment, regulating migrant labor, curbing drug trafficking and combating terrorism. This work continues today, as international law assumes a more central role across a wider spectrum of issues, including human rights law and international humanitarian law. To encourage member states to sign conventions or deposit binding instruments concerning these treaties, the United Nations hosts annual, as well as special treaty events. The treaty event of 2024 focused on strengthening the multilateral treaty framework. Thank you for watching this video.